means that 39 rand, South Africans, most South Africans, they have that 39 rand as part of their disposable income that they must spend on ICT services. Now, how does that 39 rand then how do we ensure that that 39 rand actually buys a basket of services, of ICT services, that will enable children to learn, that will enable people to look for jobs and so on and so forth? That is quite key from this slide. Now, if you look at we've talked a little bit about the international indices, and what's important in terms of this slide is that the ranking for South Africa, as it relates to affordability, appears to have a slight improvement. However, there's a decline in usage, and the main obstacle to achieving the actual usage is the affordability of services rather than the technical availability. So these are, we've used the rankings as articulated in the Global Information Technology Report of 2016, as well as the International Telecommunications report that measures the Information Society of 2017. But in both these international benchmarking, the issues are around the skills and the issues are around affordability. These are some of the highlights of the documents that has been, and of course, ICASA, the authority is coming through directly after the department's presentation, and they'll talk more about the biannual report that they publish, as well as the benchmark report on the prices. But suffice to say that in terms of data, in terms of the data market, the poor people in South Africa, because they are mainly in the prepaid market segment, they pay more than people that are in the postpaid market. And the burden of cost of communication in this country still reside with the poor. That's quite key. And one of the things that the authority has been able to do was to benchmark just Vodacom's prices, what they charge South Africans vis-a-vis what they charge their own customers in other countries. And in terms of that information, or in terms of that report, for the 1 gig data bundle prices, for instance, Vodacom in South Africa charges more than they charge people in Egypt, more than they charge people in Nigeria, and that in terms of the 2 gig as well, South African consumers are still charged more than what the operator charges its own customers in those other countries, in those countries as well. From our side, Chairperson, I think in terms of our Cost to Communicate program, we look at the work that the Competition Commission is doing on this very market inquiry, but we also monitor the developments insofar as the ICASA is concerned. In terms of the ECA, the minister issues policy directions to ICASA to address certain matters, and one of those is the high cost of communication in South Africa. And they are currently currently what we are monitoring is the implementation of the policy direction that the minister issued to ICASA to address the ineffective competition in broadband markets. That work is underway, and I'm sure the authority will speak to it immediately after this. One of those issues now, as I mentioned earlier on, is the data services market inquiry that brings us to this session today. Also the call termination market review, as well as the implementation and finalization of the end user and subscriber service charter regulations that addresses issues of price transparency, what they call disappearance of data, and general consumer protection. And as you can see, in terms of the status of this, is that work has now, it's not being implemented, it's been halted due to the court interdict. We now move into the policy direction, Chairperson, as well as the key provisions as articulated in the Electronic Communications Amendment Bill, and I'll hand over to my colleague Alf, who will speak to those issues. Thank you.
Thank you. So, starting with the white paper, it really gives a cross-government leadership by facilitating more of a multi-stakeholder participation approach across government. And then with various interventions to reinforce fair competition and facilitate innovation in the converged environment, to address horizontal and vertical integration across the value chain. Some of the interventions provided in the white paper include policies to address the digital divide, to ensure affordable access by all to ICTs, approaches to address supply-side issues and infrastructure rollout, including the management of scarce resources, especially spectrum, and to facilitate open access, including rapid deployment. On the demand side, the issues include facilitating inclusive digital transformation across South Africa. The white paper also provides for the licensing of a wireless open access network, which is really a new concept under the legislative and regulatory regime we've had so far. That's really an ECNS type provider that provides services at wholesale level, but with emphasis on wireless. Then the establishment of the WAN and the assignment of high demand spectrum to the WAN is seen by us and the white paper as a mechanism to ensure that this scarce resource is shared among many licensees. We've clarified before that the WAN is not intended to be government owned, but to be a private sector led and managed and owned initiative operated on commercial basis. The creation of efficient, uniform and competitive and responsive open access networks are critical to enable players to compete on equal terms in our move towards more effective competition. To promote transparency and non-discrimination across the broadband value chain. To open high demand spectrum for use by multiple operators. We've seen, due to the market liberalization and court judgments that opened the market to many licensees that do not have access to spectrum as the main incumbent operators. And to encourage service-based competition, which will increase consumer choice, including the reduction of costs. To reduce market entry barriers and enable sharing of infrastructure and scarce resources, thereby reducing duplication of infrastructure. Government also supports the wireless open access as a means to meet some of the policy objectives we have, cost to communicate being critical for this hearing, duplication of the last mile infrastructure that's not required, encouraging service-based competition. The wireless open access should also be implemented in a way that increases investment and encourages an effective and efficient use of resources. I think it's well known that the Minister then, following agreement with industry, commissioned a CSIR study to determine the spectrum requirements of a WAN. The study focused on unassigned high demand spectrum bands, the 700 and 800 megahertz and the 2.6 gigahertz. In view of those recommendations made by the CSIR, the matter was taken to Cabinet that really approved in principle that spectrum can be assigned simultaneously to both a WAN and to other interested parties. The Minister in ICASA also reached a settlement following the court case. And that paves the way for us and for ICASA to assign the spectrum going forward. Following the ICASA consultation, Minister also proposed policy directions that are out for public comment at the moment that suggests how the unassigned high demand spectrum can be assigned. Then, Chairperson, turning to the proposed policy direction itself on slide 17 and then 18. So it really consists of two parts. The first dealing with licensing an ECNS licensee that provides wholesale services. We've coined it the WAN in the policy direction just because it's commonly known under that name, though the ECA do not specifically have such terminology. And then the second part provides for the assignment of spectrum to other licensees. Now, the first part in the first part, ICASA, we're proposing to direct ICASA to issue an ITA and accept and consider applications for an IECNS license and to consider the licensing of spectrum for the WAN. We say that the WAN must provide wholesale open access to its networks and facilities and charge regulated wholesale rates to ensure the reasonability thereof. The WAN is not a public entity, as indicated. Some requirements have been inserted to mitigate the effects of a potential monopoly WAN in future and to ensure that the firms in the consortium are limited in their ability to engage in anti-competitive conduct, in line with recommendations we've received from the competition authorities. The authority must perform strict regulatory oversight. It's one of the conditions set, and consider imposing regulatory remedies on the WAN to ensure effective competition, and really to ensure that remedies and safeguards are built in to ensure that there are no anti-competitive effects. ICASA is also requested to consider incentives for the WAN, such as reduced spectrum application fee, only covering administrative costs, reduced and waived radio frequency spectrum license fees for a period of 5 years, immediate facilities leasing of networks and facilities of the incumbents, or rather the successful licensees that are assigned the additional or remaining high demand spectrum. Another significant incentive is that the spectrum licensees that are assigned the currently unassigned high demand spectrum must procure a minimum of 30% capacity from the WAN as soon as the WAN is licensed for a period of not more than 3 years. So this would be an individual obligation per licensee, and then the percentage to be procured by each licensee may be proportionate to the amount of spectrum received by such licensee. So that's the first period, and as indicated, that's individualized procurement. But then there's a second period. The authority may determine that after the expiry of the period contemplated, after the expiry of the first period really, then a minimum of 30% capacity can be procured, but now it's collective by those licensees that were successful in getting the remainder of the spectrum. Of course, these periods are set to also assist the WAN to become viable. But it can't be ad infinitum. There has to be an end period as well, but at the same time enabling offtake. The authority should also consider delayed imposition of wholesale rates. So though we put a requirement that rate regulation must happen, we say as an incentive, at least determine a period within which regulatory forbearance really takes place. The authority should also ensure that the applicants for the WAN have a viable business plan and are able to build and operate the WAN. Turning to the second part, so that's the spectrum not assigned to the WAN, but that's available for other interested parties. It enables the authority to urgently consider the licensing of spectrum for such other parties. The assignment of the additional spectrum must ensure that government achieves its policy objectives, and therefore there are also obligations imposed in return for such spectrum. These include that the successful applicants or recipients must lease its existing networks, if they have such networks, to the WAN upon request, really using the existing facilities leasing framework, but strengthened by ICASA to ensure that it's working and that true access is given. The licensee must procure capacity in the WAN. We've spoken to that under Part 1. The spectrum must be assigned subject to chapters 8 and 10 on facilities leasing and 10 on competition. The USO obligations are imposed on the licensees, and importantly, those obligations must be complied with in rural and underserviced areas first, before it can be used in other areas, so that we do not repeat history. This will ensure achievement of one of the key policy objectives to ensure rural coverage. Of course, bringing in compliance with the empowerment requirements set out in the ECA, A decision has also been taken to open the process to both existing ECNS licensees, but also any other potential applicant for an IECNS license. To ensure regulatory certainty, the terms and conditions imposed by the authorities should also remain in force. That's because of the parallel legislation proposed to Parliament that some assurance must be given to licensees that the terms and conditions would not change halfway through the process. Then, Chair, the ECA bill. I've spoken about the white paper that provides the overarching policy framework. There are various policy interventions. This particular bill do not cover all policy provisions in the white paper. It merely tackles a few important ones. In Parliament, the chair of the Portfolio Committee already said, but is this not too much in one go because of the number of provisions in that amendment? That's quite difficult to process in any process. But in any event, so the reinforcement of competition regulation, supply-side issues, infrastructure rollout, including open access to infrastructure, rapid deployment, and then spectrum are some of the issues from the white paper carried over into the bill. I have a few slides on problem statements. So when it comes to rapid deployment, there's a lack of balancing of rights between the ECNS licensees to enter property and deploy infrastructure versus those of other landowners and municipalities. Depending who you talk to, of course, there are different interests involved. Then infrastructure is duplicated. We all experience that with multiple trenching. A lack of coordination between large numbers of stakeholders, even just among municipalities, but also, in my view, among operators. Then there's no consistent, simple, and coordinated approach among government departments and agencies in processing various types of approvals, which we must find a solution to. There's no dispute resolution mechanism, leading to many disputes going through the courts, with many judgments following and even more uncertainty arising in the end. In terms of spectrum, there's an opportunity to improve the description of the role of the Minister and ICASA to avoid misunderstandings in future. There are also gaps in the spectrum management regime with regard to alignment between universal service obligations and spectrum. And the spectrum regime is exclusive at the moment, which promotes economic growth for a few strong incumbent players, which I'm told have already presented here. But that results in an inequitable assignment of spectrum, which we must address in the interest of potentially 400 other licensees that can't get access to spectrum. Then open access, again, the infrastructure market, especially now that it's about broadband, we see ineffective competition. There's infrastructure sharing bottlenecks. There's the sharing where it suits the access provider, but where it doesn't suit the access provider, such access providers can conveniently abuse the system and through the facilities leasing process and court processes prevent sharing. The broadband infrastructure market's concentrated, as I said, few strong and vertically integrated players. Then the cost to communicate is high, and one of the reasons would be the duplication of infrastructure in our view, which costs may be passed on to consumers. We also say that though there were successes under the competition chapter of the ECA, more can be done in this regard. Regular reviews of the effectiveness of competition must take place, and it requires an ongoing assessment of the relevance of traditional market definitions. The interests of consumers must be paramount in weighing up options and determining if competition-related interventions remain relevant or necessary. But critically, will come to the solutions under the ECA. And then, of course, we believe that there could be synergy between ICASA and the Competition Commission, at least, where the parties can draw on their respective expertise. On rapid deployment, so the bill seeks to introduce a governance framework where a rapid deployment national coordination center is planned and is already being piloted, and that coordination center being overseen by a rapid deployment steering committee, and the steering committee comprising of representatives of various stakeholders that play a role in the space, especially from an approval and government process side. It makes provision for the rights and obligations of licensees when deploying networks, to expedite all applications and related processes for approval, authorization, license, permission, exemption, and processes relating to participation required by various laws. It also deals with access to buildings and high sites, regulations on processes and procedures for single trenching, though initially we put a lot of our proposed policy provisions in the law. We've deferred a bit on that and enabled, due to some of the complexities pointed out, enabled ICASA through regulations to prescribe the detail of that in due course. Then the RDNCC must provide support, promote, and encourage. So it was a bit forceful in the first versions of the bill, but it now plays more of a collaboration, cooperation, supportive, and promoting role. With regards to spectrum, though this is not new, but we clarify that the Minister does the spectrum planning and allocation and will in future develop the National Radio Frequency Plan, whereas the Minister currently really just approves it, and ICASA to continue doing the assignment and play the assignment and licensing role. Then there are lots of new provisions emanating from the white paper. We start dealing in more detail with spectrum trading, sharing, and refarming. We deal with the use it or lose it principle, with some exceptions being inserted for SMMEs that may have longer periods, for example, than the prescribed 2-year period. The bill enables the simultaneous assignment then of spectrum to the WAN and other licensees. It also provides that currently assigned high demand spectrum do not have to be returned. So the initial provision said that by the end of license terms, existing spectrum must be returned. We were following some public comment in this respect, and our own public hearings held, inclined to then change that provision and ensure that rather towards the end of the licensing period, ICASA can conduct a process and a type of an inquiry where they then make recommendations on the terms and conditions that must apply to such spectrum prior to renewal of such licenses. Of course, this paradigm shift is necessary because we're changing spectrum from the way it's currently being used to an open use of spectrum, and therefore the situation can't just perpetuate in the future. The nature of the status of the spectrum and its use must change going into the future. Turning to roaming, over the past few years we have started with a national roaming study and then later made a number of commitments, especially at SADC level, and though some progress have been made, I don't think we are where we want to be, and then that necessitates some intervention in the legislative framework. So we're inserting a new chapter 7A to make provision for international roaming, though our key focus is SADC roaming at this point in time. It places an obligation on the authority to then make regulations in this regard, but we also ensure that the economy won't be hurt in the process, and one of the conditions is that a reciprocal application of such or any obligations resulting from international roaming regulations imposed on our operators. The section also enables the authority to obtain information from operators and to share that with the appropriate authorities. Then on open access, the proposed section 19A then deals with the licensing of the WAN. I think I've covered it reasonably well under the proposed policy direction. On open access, we then convert, noting that the whole new open access framework, it doesn't exist except for the reference to the word open access once under the current ECA. The true framework doesn't exist. We have a limited form thereof in the form of facilities leasing with its own shortcomings, but we have to now convert that whole framework into something new and then start building in all the new obligations foreseen for sharing on electronic communication network service licensees. So it seeks to oblige ECNS licensees to provide wholesale open access upon request. Really the same things you find in the facilities leasing chapter, open access agreements, and that access must be provided on effective, transparent, and non-discriminatory terms. So that's just the general open access principles, and that would apply to anyone with an ECNS license. Then the bill provides that open access does not apply in the case of technical inability. So we've limited the reasonability test to include only technical inability, which is a factual consideration that can easily be resolved, as opposed to the economic and financial reasonability test that's abused by access providers. The bill also excludes broadcasting signal distributors that were not really intended for open access here, and really a different legal process exists for them. The competition chapter, it's amended to ensure that ICASA must define all the relevant markets upfront. We set a time frame there because a lot of other processes under the ECA are dependent on this market definition, and it's therefore critical that it happens as quickly as possible. It requires the authority to then publish a schedule. It's very similar to what I think ICASA is doing in any event at the moment, but to publish a schedule that then shows which markets would be prioritized for review going forward, and then to update those processes regularly. And then importantly provides for the cooperation between ICASA and the Competition Commission. Our initial drafts really wanted some of the decisions per the white paper to be at least be considered for alignment between ICASA and the Competition Commission decisions, but we've realized that those would infringe on the respective mandates and jurisdictions under the enabling legislation. So we've toned that down in accordance with recommendations from both those authorities, and instead focused on strengthening the MOU that exists between the regulators. Chair, in conclusion, this bill does not address all the aspects of the white paper, but it's, in our view, certainly a good start. It's now, as the executive and government, we are satisfied with the bill as introduced in Parliament, and we look forward to Parliament's consideration of the bill, but it's obviously within the hands of the legislator for now. With regards to perhaps the outcome of this inquiry, it could also assist the department when we do our second round of amendments to our legislation, especially the ECA. We'll certainly benefit from recommendations of this inquiry, also for purpose of our legislation. Thank you, Chair.
Yeah, thank you, Mr. Nkuna, Ms. Masemola, and Mr. Wilt. Mr. Aprotsky.
Thanks very much. Perhaps just the first question, I've got a few specific questions, as I'm sure we all do. Maybe the first question is, as you'll understand, this is the data services market inquiry for the Commission, and the obvious question is, how can data costs be reduced? How do you, in terms of the policy and legislative environment that you've laid out, the policy directive and the ECA bill, how do you see that impacting data costs, and by what mechanisms do you think it'll impact data costs? And when I say data costs, I mean prices.
Well, thank you for the question. So it's a combination of things. I think the majority of provisions under the ECA, for example, in one way or another, in our view, contribute to the reduction of costs in general. If one really takes the presentation or chapter by chapter, the ECA, you can probably identify a related intervention in each of those. But starting with rapid deployment, for example, I mean, on the argument of operators, if there's less infrastructure and there's less infrastructure duplication, then surely there must be a cost saving that in turn can theoretically be passed on to consumers. Similarly, if we talk about, well, just under rapid deployment, for example, we make provision for adequately served, again, to avoid a duplication of infrastructure. Under rapid deployment, we are trying to move towards cost-based pricing, where municipalities and others that must provide forms of approval must strive towards rendering those services and those relevant approvals at cost to cover the administrative costs, as opposed to a money-making scenario or an income generating mechanism. One can probably identify more issues just under the rapid deployment chapter. If one turns to the wireless open access network, again here, because it's a mechanism to share firstly spectrum and a mechanism to create one network that can be accessed by potentially hundreds of other licensees to render services, it creates the opportunity to improve competition, for example, and to enable wholesale services at reasonable cost provision. If you link that to wholesale regulation of the wholesale costs of such one, it in turn can certainly address the cost to communicate. Jumping to spectrum, I think if one reads into the spectrum, the various obligations imposed on the operators, a number of policy objectives can be achieved in the whole spectrum allocation and assignment, well, spectrum assignment and licensing process. We've gone through them. Then on the open access framework, it'll take time to establish and make it fully functional. But as you create the new open access regime, there would be different categories of licensees under that regime, including so-called vertically integrated entities and what is termed deemed entities under the ECA. So the deemed entities, once they are deemed following due process, will attract the full bouquet of open access obligations. And those obligations would include rate regulation. So, and that certainly is a direct intervention to ensure a reduction of costs. Then, by lastly just improving, well, not lastly, if we turn to SADC roaming, again, it's because of complaints, especially against South Africa on some of the SADC roaming costs, that it forces an intervention to ensure that roaming costs are regulated and are reasonable, starting off in the SADC region based on the decisions taken at SADC level. And then perhaps lastly on the competition chapter, that we've seen some of the successes of ICASA under the competition chapter with the wholesale termination and the mobile termination rates and the inquiry on that and the rates imposed subsequently, that it arguably has reduced the costs. And we believe that improving the competition chapter and performing more market reviews and market definitions, that more successes can follow. Because of course one of the pro-competitive measures that are possible under the under Section 67 of the ECA is the imposition of rates and rate regulation. So we're not there yet, but it's an existing mechanism. It's been around, but if better implemented, I think it's another mechanism that can reduce costs overall. Thank you, Chair.
Yes. If I may comment, we have done an analysis of the market, both the supply side and the demand side. Now, our own observation is that on the demand side, there is a lot of innovation that is taking place. I mean, you have got so many innovations that are being done, even by young people. Because in our environment, for a person to come with software, you don't need to build a building like this. You know, you can just innovate. So there are thousands of innovations that are coming up, especially from young people. But we've realized that the supply side makes it very difficult for those innovations to take up. And we're trying to tinker with the supply side so that we can drive more innovation on the demand side and ensure that those innovations contribute to the reduction in the cost to communications. We know of so many OTTs, over-the-top initiatives by young South Africans, which will benefit from this intervention that we are proposing in the policy and in the amendment to the legislation.
Thanks very much. I suppose one of the statements in your problem statements that you mentioned a few times is this concept of infrastructure duplication, which you're trying to guard against. I suppose my question, and maybe it's a bit conceptual, but one of the submissions made, or a couple of submissions made in these hearings, was the example of the undersea cables, where you've now got 6 cables landing in South Africa, and this is pointed to as a reason for undersea or international transmission prices to have come down substantially. I mean, how do you know, and how do you think about the concept of infrastructure duplication? When is it competition that results in a low price, and when is it duplication that results in higher costs? Because I would think that we have to be careful about, you could fall into two sides. You could get too much infrastructure if there is a duplication issue, or if you're so wary of infrastructure duplication that you actually cut out infrastructure competition. I mean, how do we provide for that, and how would we provide for that through the amendments that you're making or planning to make?
No, thanks for that. You are right that it can achieve both ends depending on what it is that you are doing. On one side, it can help you to deal with the high cost of infrastructure, but there may be unintended consequences. And the question is, how do you mitigate unintended consequences? One of the issues that we're beginning to consider now is that it's a self-regulatory model, perhaps when it comes to the sharing of infrastructure, but with clear guidelines to ensure that to a large extent you allow the market mechanism to facilitate that, but at the same time ensure that where we need to assist and intervene, we do that. Why is government intervention also necessary? Because of the kind of approvals that you go through, because you have to go to local government. The current fee structure of local government is unsustainable for the sector. Now, if we are going to make an intervention and go to local government and ask them to allow us to deploy infrastructure without interest, obviously, even from that point of view, you will need some kind of coordination amongst the players. So this is bundled also to take into consideration the requirements of the owners of lands and other rights. I mean, just yesterday I was talking to Water Affairs, where when you cross rivers, you have to apply every time you cross a river with your broadband infrastructure. And those kind of things impose very serious constraints and high costs in the industry. So we're trying to do it on a positive note, but I take the point that there may be unintended consequences. And to a large extent, you need to include a self-regulatory part so that industry itself can mitigate such issues.
Okay, thank you. A last couple of questions from me. There's been a concern expressed to us, and I suppose you can respond to this and say whether you think it's reasonable or not, but there's been a concern expressed to us that effectively what happens if the WOAN license is not taken up? So if a WOAN licensee doesn't either apply for it or doesn't meet the criteria, is the legislation that you're proposing flexible enough to provide for an alternative?
You see, I think what is important is that to overstate time and again that the one is not going to be formed by people who are not involved in the sector. Now, the one is going to be formed by people who are already active in the sector, who are doing something as we speak, but the only thing they do not have is spectrum. So there is this narrative in South Africa that the one would be open sesame, that anyone, come one, come all. But I think what needs to be clarified is the one is going to be formed by, in the main, duly licensed entities, which are licensed as we speak. And they have been saying to us that to a large extent, they have been doing something going to the big operators, but that has not assisted the situation. Now, the alternative would have been to break down that spectrum into so many smaller licenses, which was not going to work. What is envisaged now is that a different licensed entities will come together and pool their resources so that they can work together with a guaranteed demand side. So beside the offtake that will come from the big companies, the companies that are going to form the one on their own, they are already active in one way or another. So there is also guaranteed demand from that point of view. And they will do what everyone does and go and borrow money from the capital markets to build their one. There is no rocket science in terms of how that can be realized.
Okay, thank you. And the last thing from our side, so my reading of the Electronic Communications Amendment Bill, and you've mentioned some of it in your presentation, is that ICASA would be required to do a lot more things like the market reviews every 24 months, the assessment of spectrum for renewal the year before. So one of the submissions that we've received in these hearings on a number of occasions is that a feeling or a sense that ICASA is under-resourced. And my reading of the amendment bill is that there's a significant additional burden potentially to be placed on ICASA through the requirements and these regular requirements that it needs to meet. Is there also a plan alongside this in terms of how ICASA will be resourced or what will be done in terms of implementing those parts of the legislation?
I will give the view of our department, considering that ICASA also report to another department. Our view is that the cost recovery model will work better for ICASA, to come with a dispensation which will allow ICASA to recover the cost of regulation. And our understanding is that industry, over a long period of time, has recommended for this approach to the financing ICASA. So to an extent possible, we will support any measure, any means that will ensure that ICASA is adequately resourced. And we will take this issue up with the Department of Communications, because when you look at the two departments, 75% of the work that ICASA does is with us and not with the mainstream department that oversees ICASA. So it's always incumbent on us to bring to the other departments' attention that the amendment is going to increase the mandate of ICASA, and as a result, we have to do something about the capacity of the regulator. So we take that point as the DTPS.
Okay, thank you. That's all from me.
Mr. Mahum.
Thank you, Chair. So one of the issues that was raised by the MNOs yesterday around the world is that constant investment in infrastructure is important in the ecosystem of this particular market. So there was a sense that with the WOAN and them being required to take some of the capacity of the WOAN, it might just hamper their investment incentive. What's your view on that particular point?
I think that is the complexity of competition or economic regulation by and large, because when you make interventions, you always come with intervention in the market that already exists, and there will be some kind of give and take, but we do not agree that this is going to collapse the industry. Quite predictably, when I started, I gave, although in brief, the roadmap that we've traveled up to now to have Vodacom and MTN. As in 1996, Vodacom and MTN were faced with serious challenges, and government had to do something. And as government was beginning to intervene around 2001 to create an enabling environment for MTN and Vodacom to build their own infrastructure and also to regulate telecom's infrastructure. Telecom said what is being said today. The dilemma of policy making in this space is that every time when you come with new interventions, those entities that exist will tell you that if you do this, we're going to collapse. So when it suited Vodacom and MTN that government must make interventions against what Telkom wanted, it looked like it made sense at the time. And even with the licensing of Cell C, when government was creating an enabling environment, there was a pushback. So this pushback is natural, is acceptable, is possible, but we can assure you that there is nothing reckless in what we are doing. If we are to drive this industry into the digital economy, we have to make hard decisions, but I don't think the kind of decisions that are being proposed are neck-breaking kind of decisions. I don't think that is the case. But obviously we take the point that we must always be prudent when we come with new interventions, but we will not agree that these are going to result in doom and gloom necessarily. There will be changes. There will be some losses perhaps from the point of view of the big operators. But what we must be careful about is whether those losses will result in the collapse of the two companies in the main. And we do not think that is the case.
My last question is with regard to roaming. I think there was a slide that touched on that there will not be regulation around roaming, specifically on the SADC region. And I'm not sure whether it's only on SADC region or is it also encompassing national roaming, because what we've heard from, especially from Cell C and Telkom, is that although they are roaming on both Vodacom and MTN, there tend to be issues there, specifically on seamless handover of calls. And the feeling is that because there was no regulation to the service and the quality, that tended to be an issue. So is it something that the legislation will address, or is it only specifically on SADC?
Well, thank you. Though the clause that we presented focuses on international roaming, the matter of national roaming is addressed in another way, and that is in the open access chapter. So it is the open access chapter that creates the framework of the different types of entities with different types of obligations. So one of the obligations that will fall on deemed entities would be, in addition to price regulation, it would be infrastructure sharing, with a particular focus on active infrastructure sharing. So that's where RAN sharing and roaming and those things come in. So the intention is surely to regulate it through that mechanism.
Dr. Mngube. I just want to confirm just one last question from my side. There is one central issue that has emerged in the submissions that we have received, and there are contrasting views around this issue. And the issue relates to the wholesale market, or the wholesale layer of the market. On the one hand, we have mobile network operators who are saying that we have made enormous investments into to developing the network. And currently we are constrained in terms of spectrum. And on the other hand, we have the internet service providers, who are saying that you need to create competition at wholesale layer in order to bring prices down. Once you create competition at wholesale level. So we are sitting with those two contrasting perspective on this issue of wholesale. I will broadly call it wholesale access. Because currently there are some instruments on a very limited basis, such as the MVNO model, which provide, I'll call it in inverted commas, a form of access, but on a very limited, basis. So, is your intervention in the bill in terms of enabling wholesale open access directed at this aspect, that is to create competition at wholesale level? Is that the key strategic objective of the intervention?
Yes, and I think ICASA will then deal with this issue in more detail, because up to now we have been regulating the wholesale market. It could be about a turnaround, because between now and 2006, when the Act came into being, ICASA has only dealt with one market, the wholesale voice market, which is called termination. And of course, we can debate the actual impact of that. So up to now, we have been regulating the wholesale market, but focusing only on voice. We have not regulated wholesale data markets to know what actually will transpire. And I'll ask that CASA then deal with that question in some more detail. But what we see happening is that having a dedicated wholesaler and an enterprise that is operating on wholesale basis will go in a long way, because in helping us to deal with the structural issues in the industry. You know that when you go to a vertical integrated company and impose wholesale remedies, there will always be information asymmetry. So it's inevitable that you can do as much as you want. So regulation as a tool for correcting the behavior of companies has its own limitations, and one of its limitations is the agency problem. Now, if you come with a new model to complement the agency problem, that is very visible and very inherent, then we think that the complementarity will then assist us in mitigating the problems that we've seen of information asymmetry between ICASA and the regulated firms.
Thank you. And if we again take the history into consideration, I mean, it's common cause that local loop unbundling and the policy objectives around that have received significant challenges over the years. If we turn to access to mobile networks, similarly, we understand that there are lots of concerns there. When we investigated the national roaming, we encountered a lot of complaints, but all of it's also covered under non-disclosure agreements. So the access providers, though they are complaining, or the access seekers, as though they're complaining, it's difficult for them to divulge the exact nature of the problems. But certainly there are lots of problems on the mobile access wholesale space, and therefore that's exactly what the ECA does. It focuses a lot on the improvement of and certainly it's one of the key areas being addressed, and that is competition at the wholesale level. I mean, if we look at Section 67 as indicated, the primary objective is to ensure effective competition, and it's also commonly known that one starts at the wholesale level, and it's only in very exceptional circumstances that one goes down to retail level, including for rate regulation, for example. And that's why we have the emphasis there on improving that particular chapter and ensuring better competition regulation. Similarly, that's what the one is trying to do, isn't it? It's creating another infrastructure provider in the market that would over time have the scale to compete with the large incumbents, that then in effect provides competition at the wholesale level, and it forces some of the incumbents to revisit their models and drop their prices and ensure better services to potential clients. And similarly, it's done through the open access chapter, because that's the objective of deeming entities and opening up existing networks to ensure competition is improved at the wholesale level. And all of this, of course, done as a result of concerns around scarcity of resources such as spectrum and so on. Thank you.
Yeah, thank you very much, Mr. Nkuna and your team. We appreciate your time, and thank you for your submissions. You are excused. We will take the next presentation from ICASA. Yeah, welcome, gentlemen. Thank you very much for your time and for coming. You will have the last word. So you are the last to present. But let's just do the formalities. If you may just state your full names and surname for the record, and thereafter take the oath or the affirmation.
Thank you, Chair, and good afternoon to you and to the members of your panel. My name is Wellington Mwepe. I'm the Chief Executive Officer at ICASA. I'll take the oath. I, Wellington Mwepe, swear that the evidence that I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Mr. Mwepe.
Good afternoon, Chair and your panel. My name is Nketereni Norman Gidi. I am the executive for legal at ICASA. I swear that the evidence that I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you.
Afternoon, Chair. My name is Junior Kumalo. I'm the General Manager for Policy Research and Analysis at ICASA. I, Junior Kumalo, swear that the evidence that I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Mr. Kumalo.
Good afternoon, Chair. Thank you. My name is Philemon Molefe. I'm a Senior Manager Spectrum Licensing at ICASA. I'll take the affirmation. I, Philemon Molefe, affirm that the evidence that I shall give shall be the truth, the whole truth, and nothing but the truth. Thank you, Chair.
Thank you, Mr. Molefe. Mr. Mwepe. You may proceed to take us through your submission or presentation.
Thank you once again, Chair. We appreciate that you have had a long day. I think in your case it's been a long 3 days, so we won't take too much of your time. And I think the other advantage of being last is that most of the ground would have already been covered, so we don't have to really repeat a lot of what has been said. And further, the further advantage of coming after the department is that they have done a very good work in setting the scene and giving you the context of where we come from. So we've decided to structure our presentation in a manner that responds to the question that the Commission had posed to us. But there may be one or two instances where we may deal with some of the issues that have come up over the past day or two. And then as we get to the end, we will then deal with the questions that the panel may raise. That's the outline of our presentation. As I said, it's quite brief. It just talks primarily to the questions that the Commission has raised. Just by way of introduction, in terms of who we are, I guess everybody in the room is familiar with who we are. We established in pursuant to the Constitution. We basically established in terms of Section 3 of the ICASA Act. Our mandate is what brings us here. Primarily, we established to regulate the electronic communication sector, as well as the postal and the broadcasting sector. And I think one of the key reasons why you are having this inquiry is that we are the people that are tasked with ensuring that there is provision of a variety of quality electronic communication services at affordable prices. So there are a number of pieces of legislation that we have to take guidance from, and those are listed on that slide. But the primary act in that slide is really the Electronic Communications Act, as read with the ICASA Act, from which we draw our mandate. The next slide summarizes our roles and functions. I think the key part of that slide is the fact that we're responsible for issuing licenses to industry players. We manage the scarce resources, essentially the radio frequency spectrum, and we also assign numbers. We monitor compliance, and we also enforce compliance. We're also responsible for consumer protection and dispute resolution. Overall, it is our duty and responsibility to regulate the sector in the public interest. I won't spend a lot of time on this slide. Suffice to say that the very first block that talks to investment in broadband infrastructure and increasing access to broadband spectrum is probably the most relevant part of our strategic goals for purposes of your inquiry, as well as the second one, which talks to promotion of competition. I guess if there was effective competition, one could argue we probably wouldn't be having this conversation, and we can have a debate about that. So that concludes the introductory part, Chair. This is really the crux of our presentation. So the first question that was put to us was whether or not data prices in South Africa are higher than they ought to be. And this is a very difficult question to answer, because I think one must then ask the question with reference to what. So we then took the liberty to then make reference to some of the studies that we have conducted. I think as part of our mandate and in exercising our duties, we do a lot of comparisons to compare how the sector performs to a whole lot of other countries. And the department made reference to some of the reports that we have published over the past couple of months and years. And I think one of the things that we wanted to highlight here is that there is always an inherent difficulty with benchmarks, because it's always never easy to decide which countries one should compare themselves to, because no two or three countries are ever the same. So there'll always be differences in population density, there'll always be differences in the number of operators, the geography and topography will never be the same. There'll always be differences in economic conditions. The energy and labor costs and other input costs will never be the same. So it's never an easy exercise to decide. And the factors that we consider to be important may not necessarily be considered to be important by other people. So that's the caveat that we wanna put out there. Nonetheless, we embarked on a benchmark exercise, and we opted for the SADC countries. We also opted for the BRICS countries. And we also opted for the countries in which some of the operators that are licensed in South Africa have operations. And then in conducting the benchmarks, we decided to look at the different packages. So we looked at the 500 megabytes, the 1 gig, and the 2 gig data bundles. And this slide shows some of the results that we found. So this is the first part, this section here. I don't know if people can see it. This section here is the SADC prices for 500 megabytes for prepaid data bundle. These are the prices converted into US dollars as of September 2017. And we sort of just give you the key highlights or the key outcomes at the bottom, outlining that Botswana has the highest price for that 500 meg, and that price is 26 US dollars. Then we have South Africa at $7, then Mozambique having the lowest. And then the other factor that has obviously been raised when these conversations are held is around spectrum. Then we thought we should just emphasize that the 3 countries that we have outlined above, South Africa, Mozambique, Botswana, all of them have assigned those bands, the 900, the 1800, and the 2100 megahertz bands. But there may be other factors that may account for those differences other than spectrum, which is why I think, Chair, as I started, I then outlined that no countries will ever be the same. Even if everybody assigned the spectrum, there may still be other factors that may account for why the prices will still be different. And I think that's an important point to highlight. And we looked at the 1 gig, again looking at the same period, looking at again the SADC prices, and we found that South Africa was in the 6th place in terms of the price comparison. So again, in that space, we then also found that the South Africa's most expensive 1 gig bundle is obviously lower than that of Zimbabwe and Swaziland, and one can argue that perhaps that might not be the best countries to compare ourselves to, but that's what the results show. Again, moving to the 2 gig for the same period, for the same group of countries. The results again show that in the highest price category, you have Zimbabwe, and then you have South Africa, then you have DRC being the cheapest at $1. Then the Mozambique's average price for a 2 gig data bundle is at $3. We then concluded the exercise by looking at both MTN and Vodacom other operations to assess how the pricing looks in those other markets. So for MTN, and this is not all of their operations, so we just selected a few for which we could easily find the data. We looked at Afghanistan, Benin, Botswana, Cyprus, Ghana, Iran, Ivory Coast, Liberia, Nigeria, and Zambia. And again, that data is as of December 2017. So the highest rate across those countries we found to be in Cyprus, followed by Botswana and Ghana. Then we found the lowest in Liberia, Iran, and Afghanistan. So when we compare MTN South Africa to Iran, that percentage is a bit too high. Being a lawyer, I'm not very good with numbers. So, but that's what it says. That's the differential between what is charged in South Africa and Iran. Again, spectrum being a key issue, you will note that in Iran the 2.6 gigahertz spectrum has been assigned. In South Africa, it hasn't. For Vodacom, we looked at not just the Vodacom operations, but we included Vodafone as well. Obviously, Vodafone being a majority shareholder in Vodacom Group, and the results are as shown there. I think this was highlighted in the department's presentation as well, because I think they got this from a previous released report. So the results, I think the key highlight or the key takeaway there was that if you look at South Africa and Egypt, there is that percentage differential in the pricing of the 2 giga bundle, the 2 gig bundle offering there. So that's the information that we thought we should flag in responding to the question about are the prices higher than what they ought to be. But you will see, Chair, that a number of factors come into play in accounting for the differentials. And maybe with the information and the data that might have been shared over the past 2 days, the Commission might be able to determine whether are the prices higher than they ought to be, or are they where they're supposed to be, given our conditions and the constraints that might have been highlighted. Are the differentials that we see reasonable, and would those differentials come down once we have alleviated the constraints and the other factors that might account for the differentials? The second question that was put to us was, to the extent that the prices are higher than they ought to be, what are the factors that drive these outcomes? And again, even with this question, one does not want to be presumptive of the outcome of this process, or even of the outcome of the processes that ICASA ought to undertake. Because I think the exact factors ought to be determined through this inquiry and through the market reviews that ICASA must undertake. However, there's been a lot of discussions and research that's been undertaken, and from that anecdotal research, there are a number of issues that have been highlighted. And even in these forums, in the past 2 or 3 days, a number of them have been highlighted. One that comes straight to mind is the issue around spectrum availability. I think a lot has been said about that. The other issue that has been raised, and I think the department has highlighted it as well to a greater extent in discussing the amendments that are contained in the bill, relates to the issue of rapid deployment and rapid deployment of infrastructure. So we have framed it there as rights of way and way leaves. So the fact that when operators have to deploy infrastructure, they have to jump a number of hoops. There's a lot of government entities at national, provincial, and local government level, as well as state entities that are involved in granting all manner of approvals. And different authorities have different standards or different fees or different processes. And all of those may contribute significantly to the costs that operators have to bear in making sure that there is infrastructure that enables them to provide the services that are required to be provided. There is the issue of the market structure. I think a lot was said yesterday by some of the presenters about the market structure possibly being a duopoly, and not really being conducive to prices coming down. But I think there is also a factor around the behavior of market players. And you can look at behavior in 2 ways. The one way is to say perhaps those that are perceived to be dominant might abuse their position. But there is also the factor that perhaps those that are supposed to be challenging the established players are not necessarily doing a good job at it. And I don't run businesses, but it's not for me to say. So there's always 2 sides to the story. But there is also the reality of economic conditions that also have a bearing on the costs and the prices that people ultimately pay for services. So some of them might, just a couple of examples there, this issue of energy costs, access to capital, and even the cost of that capital. In the previous slide, I highlighted the labor cost as an example. This is also a very technologically intense sector. Technology changes all the time, and that might also come with a lot of cost, which perhaps might be a contributing factor to some of the issues that we see translating into the prices that are paid. The last issue on that slide talks to the policy and regulatory environment. I think some presenters raised issues on that one as well yesterday. And if you may allow me, Chair, just to digress a bit from the script, I think on the policy and regulatory environment, I think the DG has already made some comments about how every time there is a shift in policy, there'll always be perhaps concerns and protestations by those who are in the sector, who may be affected by those shifts, that the shifts will pose a risk. But I think what I wanted to comment on is specifically around whether or not the regulatory environment is such that it enables smaller players in particular to compete. And one of the things that I also want to specifically mention is that I think the criticism that that has been leveled at the regulator is to a very reasonable extent very fair. I think from where I'm sitting, I think in terms of ensuring that there is effective competition in the market to advance consumer welfare and make sure that prices do come down, from an ICASA perspective, we should and can do more, and we must do more, and we will do more. But I also think it's also important to highlight that there are a whole lot of other measures that the regulator has taken to support or to enable competition. And I'll give you an example. And I'll use a recent example. Let's take the call termination regulations that were just promulgated in September. So when the draft regulations came out, I think there was a whole lot of noise about how those regulations are going to kill small players. Then we had the consultation process. We came out with the final regulations, and somehow the noise died down. And I think if we were to look at the final regulations that came out, you would really see that the regulator has gone to a greater extent to try and create an environment that gives what I would call the regulatory prop-up to the smaller players to really shake up the competitive landscape. So as the criticism is leveled, I think it ought to be balanced, and it ought to be fair. And there are a number of examples that one could highlight about the measures that are available, that are being implemented. I think what I wanted to highlight though is the regulatory environment is not perfect. It certainly could be improved. But it works in a lot of respects, and I think we're doing the best that we can to make sure that we continuously improve it. The next question, Chair, that was highlighted to us is how can these factors be effectively remedied? The factors that have been highlighted as being the cause of the high cost of data. And in responding to this, I thought we should just highlight the 4 key interventions, some of which the department has spoken to, that are currently underway from a regulatory perspective, that we're implementing. So I've also thought I would highlight some of the other measures at the corner there. These are more long-term. The first one is your current inquiry. So this is something that is not necessarily long term. So that will hopefully help us in getting some relief in the immediate to medium term. The EC amendment bill is also another one that might, depending on the timelines that the legislature take, that might take a bit of a while. The last one. We have seen moral suasion work at some point when the initial call termination rates were dropped. Perhaps there's also room for that. For those who are engaged in that space, there's room for moral suasion to be applied for operators to drop their prices. But from where we are sitting, the matters that are within our control fall in that realm. So I'll start with the priority markets inquiry. So we recently concluded an inquiry or an exercise through which we identified markets that are prone to ex-ante regulation. So that report was published about 2 or 3 months ago. And we embarked on this exercise primarily to provide certainty to the market and also to enable us to allocate our resources effectively and efficiently. And we also wanted to make sure that we focus on the market reviews that will yield material impacts for consumers, and that will also drive the achievement of public policy objectives. The outcome of that inquiry, as set out in the report, is that we have identified a number of markets for prioritization. And the market have been categorized into upstream markets, wholesale markets, and retail markets. And we've listed all the markets that have been prioritized according to that categorization. But I think what is important to then highlight is that if you look at the markets that have been prioritized, you will see that they include at the upstream level, well, that have been identified. You'll see that they include the mobile radio access network service market. They include the wholesale termination services. They include international roaming services. They include mobile network services, fixed termination services. They include fixed access, origination and transit. They include mobile services. But I think what's more important to note is that from that prioritization, we have then decided to outline our plan of how we're going to conduct the market reviews in order of priority. So the first area of priority for us will be the mobile services market. That will be the high priority, and the reason why that is high priority is because we think that is the one market review through which we will deliver the material impact for consumers, and again it's in response to the public policy directives that we have had to respond to. So there was a ministerial policy directive in 2016 that we still need to address. And then in that order, we will then look at wholesale fixed access and then upstream infrastructure markets. So that prioritization, we're hoping that as soon as, depending on the timeline of this process of your inquiry, we're hoping that we will then initiate that process towards the conclusion of your inquiry, because we see our processes as being very complementary to yours, so that we don't create unnecessary duplications. The second area that I wanted to talk to relates to the end user and subscriber service charter regulations. This is the regulations that were published again in May this year. The aim of the regulations was really to provide transparency and some relief to consumers. The four main pro-consumer interventions that were introduced relate to usage notifications, in terms of which all licensees are required to send usage depletion notifications to users. We introduced measures for rollover of data, transfer of data, and also protection against out-of-bundle billing. These regulations are not yet enforced because they are subject to legal review. And the fight around these regulations is that it's really, well, it's camouflaged around the need to provide adequate time for licensees to rearrange their system for compliance. But when you look at it, if you were to look at, we'll make it practical, and I'll draw again to the DTPS presentation around the poverty statistics. So if you look at the requirement for rollover of data, transfer of data, and out-of-bundle billing, at a practical level, for an operator, if a consumer cannot have their data expire, but have an option to roll it over or to transfer it, it means that, and I don't know if I'm getting my terminology right. This is not a pricing regulation, but it would have an impact on how licensees recognize or generate revenue from consumers. So in my practical world, if I'm an operator, a consumer pays for data, they don't use it, I expire it, it means I've made free money. So when I say it's camouflaged around timelines, I actually mean that if I'm an operator and I'm able to delay the implementation of these provisions, I'm able to continue to make free money. So again, to the point around the regulatory framework being unable to deliver results, we are able to come out with regulations such as this under the current regulatory framework, and they can be enforced. I'm just hoping that we'll overcome the legal review hurdle and deliver the kind of benefits that these regulations can deliver. On spectrum, I think the department has spoken to this. So we have finally overcome the impasse that arose when we issued the ITA in 2016. So the litigation between us and the department has been settled. The minister has issued a policy direction on the assignment of spectrum. That's open for public consultation. Once the public consultation is done, the minister will then issue a final policy direction. The consultations on the policy direction includes us, includes ICASA, so we're also being consulted by the minister. And then we will also be preparing ourselves to initiate the licensing process as soon as the policy direction process is completed. The last initiative on this one, again, the department spoke to it in the context of the amendment to the bill, is the fact that we need to clear the hurdles around the rapid deployment of infrastructure. So parallel to the amendment to the bill, the minister has also initiated a consultation process on the policy direction for rapid deployment of infrastructure. And that consultation process includes not just ICASA, but the other government departments that are also playing a role in that space. And we're hoping that once that policy direction consultative process is concluded, we will have a bit more of a coordinated approach across government to enable operators to be able to roll out infrastructure in a more seamless and coordinated manner without the bureaucratic hurdles that are currently hampering the process. The last question was, what is the impact of data prices more broadly on marginal consumers, and how important are data prices for these customers? I think that the last presentation before lunch answered this question very well. I think the presenter gave an example of someone who stays in a shack in the township who is always on their phone and surfing the net. And when they were asked, what is it about the internet and them always on the phone and surfing the internet, they said when they do that, they stay in a shack. When they do that, they feel like they no longer stay in the shack. I think that's really what it's about. It opens the world for those low-income customers and rural customers and the unemployed. And the fact that they are not able to access data for whatever reason, whether it might be lack of service or access, or it might be affordability, really keeps them outside the mainstream of the economy and keeps them marginalized. So I think there is no better answer than that illustration. But ultimately, it's really about the fact that everything is going digital, and ICT is the key driver for economic growth, and there is no better way for economic inclusion and participation than through ICT. And I think this was also spoken to earlier about the fact that the pricing model almost perpetuate the divide, in the sense that if you are able to to buy a bigger bundle, your effective price per meg is lower than someone who can only afford a small bundle. So that's really the essence of the story. The exclusion gets perpetuated on the basis of how far you are in the LSM levels. But yeah, this is our last slide. I think on this slide we just wanted to just emphasize the fact that we will be embarking on a market review in terms of the prioritization that we have outlined, and we see that process as complementary to your process, and obviously we will be working closely with you as per the MOU that we have with the Commission. And then finally, we are also working closely with the department to alleviate all the policy and regulatory constraints that are there, whether you're talking spectrum or rapid deployment or any other regulatory and policy constraints that we have to deal with. And that process is underway, and hopefully it should bear fruits in the next couple of months. That concludes our presentation, Chair. My colleagues will then deal with all the questions. Thank you, Chair.
Thank you very much, Mr. Mwepe. I think we can also confirm from our side that behind the scenes there's a lot of cooperation between ourselves as well as ICASA, and we also similarly remain committed to that collaboration. I think we just have one before you close the presentation. Just one. It's really a clarity seeking question on the first slide relating to the study that you did in terms of benchmarking data prices. I think it was the very first slide. Oh, this is the, if you can just go to the, I think it was, just go back a bit. I think this is the slide that I think concludes by stating that in comparison with, there's a conclusory statement there in that slide. It concludes by stating that data prices in South Africa in comparison, and I'm paraphrasing. Yes, this is the slide. And I think we have noted that this is the conclusion in the slide, that the study reveals that South Africa data prices are not the highest in both SADC countries as well as BRIC countries. And the clarification is it relates to only one aspect. The conclusion is, of course, using countries as a comparator. So what I want to find out or to clarify is whether if one uses a different comparator, that, for instance, a comparator that references the costs of MNOs, whether one could arrive at a different conclusion, and whether there are studies that are available using different comparators.
I think I'll let JK deal with that question. I think the response to that is, Chair, that it's probably possible, but I don't think we've got that data. So when you say if we were to go into any of the SADC countries and choose an operator, or look at all of the operators and look at their underlying costs for, maybe clarify the question.
Yeah,
so
maybe if I could clarify, the price cost benchmark which I am referring to is the price cost benchmark that uses the costs of the MNOs in South Africa against data prices. That's the price cost benchmark which I'm referencing.
Okay, thank you, Chair. I think you'll see that that second bullet point that we have there actually is a disclaimer. Exactly what you are raising is what we are actually saying is the challenges sometimes of doing these benchmarks. We have not looked at the costs vis-a-vis what other operators are facing in terms of cost. However, we've said that as a proviso or as a disclaimer, those are the things that may influence the cost of data. The fact that, population densities, number of operators, the geography of that country, energy costs, labor costs, and other input costs that come with providing the services, that may have an influence on these differences. However, we don't have those costs, just to be straightforward with you.
So, but in short, what we're really comparing is the headline prices. It's not anything else. So we just comparing the headline prices for a 2 gig bundle in South Africa with the headline price for a 2 gig bundle in another country for which we could find the information, looking at all the SADC countries and the BRICS countries.
Yeah, thank you very much, Mr. Ngwepe and your team for your time as well as for your presentation. We really do appreciate your assistance. Thank you very much. This brings us to the end of this round of public hearings of the data market inquiry. We would like to take this opportunity to convey our appreciation for all the stakeholders who have made submissions to the inquiry, as well as to members of the public who have taken a very keen interest and have attended the inquiry. Thank you very much. In terms of the way forward, the process of the inquiry will continue and will unfold in accordance with the timeline set out in the terms of reference. Thank you very much.